On any given day, courts throughout the country render decisions that affect many thousands of people. Though some agree and some disagree with the rulings, our nation has entrusted the courts as final interpreter of the law. Through our federal and state constitutions, we place our trust in the U.S. legal system to treat us all equally.
Today, we'll be taking a look at the County Circuit Court, all the comings and goings, the different kinds of cases, the importance of judges and juries, and overall, taking a closer look at the many facets that exist inside this courthouse and many across the country.
As the courts interpret laws, settle disputes, and even strike down laws seen as conflicting with the protections of the Constitution, Americans transact their daily affairs.
Little do we realize that the courts allow us to carry on with our lives, from signing contracts, buying real estate, to feeling safe in our streets. Our courts do a lot more than you might realize.
A couple of documents hold the legal system together in Oregon. They are the U.S. Constitution and the Oregon Constitution. The U.S. Constitution sets up the three branches of the federal government: the legislative, the executive, and the judiciary. The Oregon Constitution establishes the same three branches for our state government. In both governments, each branch has its own role in how the law is made and used. Each branch's powers is balanced against that of the other two, and each branch has some ability to check the actions of the other. This system is known, naturally enough, as checks and balances.
The local, state, and federal governments all look to the U.S. Constitution, the supreme law of the land, for guidance.
But almost everything about the Oregon state courts that we'll be talking about today is the product of the Oregon Constitution and laws enacted by the Oregon legislature. State courts are divided into four general categories: trial courts of limited jurisdiction, trial courts of general jurisdiction, intermediate appellate courts, and courts of last resort. Multnomah County Circuit Court is a general jurisdiction court. There are 27 of these courts in the state of Oregon. The lion's share of the nation's judicial business takes place in circuit courts, like this one. Reason being that statutory law is more extensive at the state level, covering everything from the most basic personal relationships to more serious violations. The courthouse is more than a workhorse. It's an iconic American tradition. The circuit court handles about 90% of all cases in the state. It's a place where things get done and events happen. Courthouses are the center of American life. So let's see what's inside. Every case that comes through the doors has a paper trail. Over the course of one day, the court will generate a stack of paper over 6 feet high.
That's a lot of cases. Why does the circuit court get these cases? Well, the key word here is jurisdiction, the practical authority to administer justice within a defined area of responsibility.
In this instance, the circuit courts have the authority to hear all kinds of criminal and civil cases.
Criminal law is the body of laws that define a person's basic rights and duties in order to preserve a peaceful and safe society. A person who violates this civic duty may be guilty of a crime against the people and therefore face jail, prison, or some other penalty. Civil law includes all matters that are not criminal. A civil dispute involves two or more private parties. Civil law includes statutes and case law that define relationships, disputes that involve property, contracts, personal injury, and family relationships, to name a few.
It's interesting. The reality is that a very small percentage of the population is ever going to experience criminal court.
Oh yeah? Is that according to your research?
Yeah, my research.
Well, you saw how long that line was out front, right? You saw how long it took us to get in here? What do you suppose all those other people are here for then?
Well, did you know that the courthouse is home to several specialty courts, some of which offer cheaper alternatives than sending defendants to prison?
Give me an example.
Well, Project Clean Slate is exceptionally innovative.
the benefits for a lot of these folks is because they realize they can't move forward in life. I really want that job. I really want to go to school. I really want to get into this apartment. I qualify for these programs. And then they say, I'm sorry, you owe all this money. So where do you go? You can't go to an attorney because you don't have the money to pay an attorney. You got to come through Project Clean Slate. You have to be ready to step up if you really want to have these things erased.
So, how does a civil case get started? When a person or entity, such as a corporation, called the plaintiff, claims that another person or entity, called the defendant, has failed to carry out a legal duty owed to the plaintiff. A good example of a civil case would be if one citizen sued another for not living up to a contract. The objectives of civil law are different from other types of law. In civil law, there is an attempt to right a wrong, honor an agreement, or settle a dispute. If a jury or judge finds that a person has been civilly wronged, that person gets compensation, and the person who is the cause of the wrong pays.
The number of civil suits is huge. But fortunately for us, they tend to separate themselves into about 5 basic categories. On guard. First, contract law. I'll sell you 1,000 widgets if you'll pay me $1,000. Private agreements between parties. That's contract law. Tort law. Okay, your airplane crashed into my house. I'm glad you weren't seriously injured, but it broke my arm and it destroyed my house. You've got to make good. That's tort law. Property law. My spread's over here, your spread's over there. You put a fence, you thought down the middle. No siree, that's over my property line. We'll go to court and sort out where the property line is. That's an example of property law, another civil lawsuit. The law of succession, wills, passing property along to the next generation. Family law, oh dear, yes, this is the sad one. This is breaking up of marriages, separating the property out, and then the kids. Who gets custody? Who gets visitation rights? What are the rights of the children themselves? It's tough, but it all gets sorted out in court under family law. So, civil suits touch the lives of a lot of people every year.
It's easy to imagine that processing cases of this nature could be very time-consuming for the courts. So alternatives such as mediation exist.
I'm glad you both agreed to be here today. My name is Shannon, and I'd like to confirm that you're Mrs. Miller and that you're Frank Esposito. Mediation is a negotiation process, and it takes patience. I'm here to assist you in reaching an agreement. The hope is that we can have an open discussion that alleviates some of the tensions of being in a courtroom.
Mediation is a process that can help parties to a civil lawsuit reach an agreement through the use of a mediator, a neutral third party.
In some counties in Oregon, judges will serve as mediators, and this is sometimes called a settlement conference.
As long as the parties agree to the mediation process, they may be able to avoid the sometimes long and lengthy process of going to trial.
In fact, the courts encourage mediation of civil disputes.
The court system doesn't have the resources to have a trial in every civil case.
Frequently, the parties reach better resolution through mediation and, in turn, are therefore happier with the mediated result.
One of the most frequent kinds of civil suits is a personal injury case. In this instance, Joan Miller's dog bit a neighbor.
A personal injury civil suit is being filed against Joan for her actions, negligence in looking out for her dog.
Before getting here, Mrs. Miller had to be personally served with a copy of the plaintiff's complaint, file her motions, such as a motion for the plaintiff to clarify the complaint, then answer the complaint. In this instance, we'll presume that mediation failed.
The person bitten by the dog is the plaintiff, and Mrs. Miller is the defendant. The plaintiff must prove by a preponderance of evidence not only that Mrs. Miller owns and controls the dog that bit him, but also that her actions or negligence caused the damages he suffered.
Hey look, Here's another example of how the legal and judiciary system are going to help people by giving them a second chance.
Lay it on me.
It's called Community Court.
I love that show. Wednesdays, Channel 11, The Wacky Judge.
No. This is reality, not TV. I know you get confused sometimes being in the biz, but you have to be careful.
Ha!
Community court. The idea is that an individual gets the opportunity to address the root cause of their unlawful behavior and become part of the community.
Community court is going to have a wide range of individuals that go through there because they're going to be the ones that are having contact with police officers who are citing them for misdemeanor or citation type of offenses. These individuals come into court, and if it's their first time and they can fulfill the sentencing, they can usually have these charges dropped and removed from their case. The idea of community court is to have people be responsible to the community where they live and to restore the community where they live, where they've done the damage, where the crime has been done.
In Oregon, all citizens over the age of 18 are eligible for jury duty. Any given Monday, the jury room in the Multnomah County Courthouse will see 150 people present themselves for jury duty. In selecting jurors for a particular trial, the court clerk randomly selects 15 to 35 potential jurors. This select few will then go to a designated courtroom. The judge will explain the nature of the case, and the attorneys for each party have the opportunity to ask individual jurors questions to ensure that each juror can be fair in deciding the case. Once the jurors for the trial are selected, they are impaneled, and they are administered an oath to truly decide the case according to the law and the evidence presented to them at trial.
We could not keep our promise of justice without jurors here serving their function as finders of fact and voices of the community.
The judge is duty-bound to instruct the jury on the law, and jurors are required to follow the law, whether a juror agrees with the law or not. That's part of the oath every juror takes at the beginning of a case.
And then at the end of the trial, the judge will say, I remind you, these are the decisions you'll have to make. These are the rules for making your decisions.
We have visitors regularly from the European countries now forming their own constitutions, envying that we entrust to citizens, not law-trained people, the authority to resolve disputes.
Jurors stand up to the most powerful institutions in the world, sometimes including their own government. They really are the foundation of the operation of the court system and maintaining liberty and justice for all of us.
The courts get bad press because that's where the criminals go. But in reality, they are doing an amazing job keeping your neighborhood safe, providing alternatives to incarceration, and of course, protecting the rights of those accused of crimes.
A criminal case begins when an individual has been charged with breaking a federal, state, or local law.
If an individual violates a federal law, then that case will be heard in federal court.
But most of the times, crimes are described as either felonies or misdemeanors.
What separates them is the severity of the crime and the terms of punishment. The basic dividing line is that a felony can lead to imprisonment for more than 1 year, and a misdemeanor carries jail time of a year or less. The deputy district attorney, who represents the state, the maker of the law you've just been accused of breaking, is the prosecutor. If you end up being charged with a criminal offense, you become known as the defendant. Being charged is a formal accusation. For felonies and serious crimes, this is called an indictment. The courts aren't just about jails and prisons. The judicial system offers alternatives to going down that path.
I think I went down that path on my hike last weekend. When you get to the Y in the road, you go to the right or the left. I can never remember.
Another great opportunity that exists in the court system is called STOP, which stands for Sanctions, Treatment, Opportunity, and Progress. It's part of Multnomah County Adult Drug Court.
That's probably why they call it STOP.
It's designed to offer an opportunity for people who face felony-level drug-related charges, so most commonly possession of heroin, possession of methamphetamine, any other scheduled controlled substances. Once they are facing those charges within the court system to have an opportunity to do a drug and alcohol treatment program. The goal generally is that they not have the rearrests or new convictions once they complete the drug and alcohol treatment program.
Driving under the influence of intoxicants. Yeah. Well, it's not uncommon for people from every walk of life to be pulled over for being under the influence of something. Ooh, for those people who have sobriety is a constant struggle, there's something called DISP, or DISP. It stands for DUII, Intensive Supervision Program. It can help.
It's really a treatment court. And I think studies have shown time and time again that unless you deal with the underlying reason for the criminality, throwing them in jail isn't going to solve the problem. They're going to get out and they're going to drink again. And they're then going to be another danger to you and I. So unless you deal with the underlying cause, which in this case is addiction, you haven't solved any problem. So our goal in the treatment court is to deal with that addiction. It's phenomenal that 88% of the people who successfully graduate from the DISP program no longer have any involvement in the criminal justice system during our current tracking period, which is 12 years. So the program works.
Let's peek in on a criminal case. Here we see Judge Wyatt presiding over the case of the State versus Hutton. The two-sided structure under which the criminal trial courts operate requires the prosecution to convince the jury of the defendant's guilt beyond a reasonable doubt. The defendant is presumed innocent until proven guilty. To be on trial, Ned Hutton first had to be issued a citation or be arrested. The next phase of the process is arraignment, or the first court appearance. This is the point at which Ned Hutton is advised of the charges being brought against him by the prosecutor. The judge appoints counsel for Ned if he can't afford a lawyer, and requires him to enter a guilty or not guilty plea. For Ned to be convicted of the crime he's charged with, the prosecutor must prove that Ned intended to do something that the state legislature has determined is criminally wrong. The bottom line here, a person is not guilty of violating a law until the court says so. As a matter of constitutional law, Ned is entitled to his day in court.
To prove something by clear and convincing evidence, the party who's brought the lawsuit, the plaintiff, has to convince the trier of fact, who could be the judge or the jury, that it is substantially more likely than not that the evidence being presented is true. So this is a stricter standard than the preponderance of evidence. But there's one more. Higher than clear and convincing, beyond a reasonable doubt. Most typically, we find this in criminal cases. So what exactly establishes proof beyond a reasonable doubt? The proof would be so convincing that reasonable people would be willing to rely and act on the evidence without hesitation in their own affairs. Or, to put it another way, the facts establishing the defendant's guilt are almost certainly true. Now, this doesn't mean that the judge or jury can't have any doubt, but only that no reasonable person would doubt the truth of the evidence presented.
The judge has a very important role in the system. And what we do is we maintain order in our courtrooms, we interpret the law, and we keep the pace of the hearing or trial going.
It includes deciding what evidence you will get to hear, what evidence the law says you may not hear.
You may disagree with the decisions that we make, but one thing you can be confident of is that our decision was made impartially. And what I mean by that, it was made without outside influence.
Impartiality has everything to do with giving parties a fair opportunity to be heard and then understanding the arguments. To those arguments, then applying a fair reading of the law.
If a party decides to give up or waive the right to a jury trial, then the judge takes on both roles, the role of deciding the facts as well as interpreting and applying the law. And of course that means all the weight is on the judge's shoulders.
Hey, remember how you were talking about alternatives to criminal prosecution and stop and DISP and stuff? Hey, I've got a specialty court here that I bet you've never even thought about.
How do you know what I think about?
Psychic. Mental health court. So mental health court is for individuals who commit low-level crimes and they might have some mental health problems. So it's small stuff like nuisance crimes, minor offenses.
In my mind, what we're trying to do is we're trying to identify these people who are mentally ill and in the criminal justice system and help them move out of that system and help keep them out. The focus for us is, do they have the mental illness? Do they have the right crime? And will our court be able to support them and help them meet the court criteria to successfully complete their probation or whatever it is they need to be doing to move out of the criminal justice system?
So I hope by now that we've quite clearly established the differences between civil and criminal cases, the role of the judge and the jury. But what about verdicts and sentencing?
There are verdicts in both civil and criminal trials.
If a jury finds a defendant liable in a civil trial, the jury gets to decide, within the limits of the law, what the plaintiff's compensation will be.
In a criminal trial, when the jury or the judge finds a defendant guilty, the judge decides what the sentence will be.
Criminal sentencing also occurs after a defendant enters a guilty or no contest plea.
The law establishes guidelines for the judge to follow when issuing a sentence, such as the type of crime and the defendant's criminal history. But the judge in a criminal case generally has some leeway in determining what the penalty will be.
The verdict has been announced and sentencing has taken place. Where does it go from here? Is it the slammer, the clink, jail, prison? What is the correct term?
Misdemeanors carry a term of 1 year or less, and you go to jail, which is a county or city administrated institution.
Many misdemeanor sentences are actually just a fine, without a jail sentence.
Felonies carry a term of more than 1 year in a state or federal prison.
Okay, it's a lot more complicated than that. But that's the simple take on jail versus prison and how the crime you've committed decides your destination. And for most of us in criminal court, it's not just going to be about jail or prison, but parking tickets or getting caught speeding. These are known as violations. No custody, no probation, but yes, you guessed it, a fine.
And that's why there is a whole area dedicated to payment collections here at the courthouse. Of the thousands of defendants sentenced each year, many will receive probation. Most are also required to pay fines and fees.
And sometimes people just need help connecting to services to help them through a really tough time. Family Court Services support Domestic Relations Court in providing direct services to parents and children who are experiencing the transition of divorce or separation.
We know now very clearly that if we can help parents reduce their conflict by reaching practical agreements about their children will not be exposed to conflict that we know is harmful. And we know that when parents have less conflict, children are more likely to have access to both parents. And we know, again, from research and probably common sense, that most of the time it's really important for kids to have relationships that are solid with both parents. So what our hope is that all of the things we do here all serve to reduce conflict between parents and increase the likelihood that children are going to have positive connections with both of the important adults in their life.
The goal of these specialty and support programs is to improve the lives of people and their families, and to strengthen and protect the communities we live in.
And I've got to say, there's another gem down the hall, court care. We've got 3 caregivers who can take care of children under the age of 6.
The greatest benefit is for the kids. The children are saved from having to witness a parent possibly being taken away from a courtroom in handcuffs, or from having to listen to a parent recount an event of domestic violence, or from listening to their parents fight over the child. And so that is a huge benefit to each child. We are averaging 80 to 100 children a month in court care, and these are children who are under 6, who are our most vulnerable children.
Well, what a day. Welcome back to the filing room. It looks like we made it through some of these cases.
Got a brand new batch for you.
Oh, couldn't we save some of these till tomorrow?
Whether you've been here to pay a parking ticket, for jury duty, or for your day in court, I hope we've managed to demystify the workings of the courthouse.
And shown that there are many positive steps being taken to help people get back on track with their lives and become productive citizens.
The courthouse is vital to the American way of life, and there's a lot more going on here than just sentencing criminals.
The courts are there for you and me. They protect our individual rights and assure that no one is above the law. And remember, everyone is entitled to their day in court.